Good afternoon, and thank you for joining us again this afternoon. The South African Bar Association hosts bi-weekly sessions to engage in various topics within the legal profession, whereby we invite the speaker to present or discuss their preferred topic and further engage with the participants. Our esteemed guest today is Mr. Edward Luke II, who is one of the leading lawyers in Botswana with a wealth of local and international experience. He is listed in the Who's Who of the Southern Africa and the International Who's Who of Professionals in Washington, D.C. Mr. Edward Luke is an international arbitrator and a fellow of the Chartered Institute of Arbitrators in the UK, Kenya, and Zambia. He is a fellow of the Southern African Arbitrators Association in Sandton, South Africa. Mr. Luke has also spoken at several international arbitration conferences. We thank Mr. Luke for making time to grace us with his presence today, and we look forward to his engagement. Without further ado, I shall hand over to Mr. Luke. Thank you.
I'm going to take you to why I stopped being a litigator and then became an arbitrator. So let me start off with, I have had a very unique practice in Botswana, very, very unique. First of all, my uncle and godfather was the Chief Justice of Botswana. And so I had a very unique privilege of appearing before my uncle in the High Court on several occasions. And I must say that the experience was quite horrific because my uncle gave me a really, really hard time when I used to appear before him in court. He was, before that, the Chief Justice of Sierra Leone, and then the Judge President of the Gambia Court of Appeal. He became a judge very, very young, at the age of about 37, and so he had a wealth of experience and was such a brilliant judge that he gave me a very, 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 very difficult time in court. The first case I'm going to refer you to is a drugs case I did before a magistrate who was the principal magistrate in the magistrate's court in Gaborone. I had two clients who were charged with possession of a habit-forming drug. And these chaps had been arrested by the police at the border, and they found a whole stash of drugs in their car. And the younger brother, when was asked by the police what these were, kept quiet. The elder brother said these were mandrakes. The magistrate, who later became a judge of the High Court in the Gambia, the High Court in Swaziland, and then the Judge President of the International Criminal Court in The Hague, and is now presently the Botswana High Commissioner to South Africa, found my younger client not guilty, but convicted my elder client, the brother. And I appealed that conviction to the High Court. The High Court refused my appeal, and I then appealed to the Court of Appeal. The Court of Appeal was constituted by, and the judgment was given by a South African former judge, Justice of Appeal Trengove. And they both decided, the Court of Appeal of three judges decided that my clients was not going to be found, the appeal was not going to be allowed, and that the statement made by my clients that the drugs were mandrakes was an admission and not a confession. And therefore, the appeal was dismissed. We have been very, very fortunate in Botswana to have had several of your leading judges sit on our Court of Appeal. And I'm going to name a few. Bezos, who is, of course, Nelson Mandela's lawyer, Issy Maisels, whose famous chambers are in Sandton, was the judge president of our Court of Appeal. Cecily Kentridge was also a justice of our Court of Appeal. Steyn was on our Court of Appeal. Tebbet, Kumlieben, Zietsman, Schreiner, both Shriners, the father and the son, were both judges of our Court of Appeal. Foxcroft, Howie, Brand, Strangrove, and of course Huckster. So, and I've had the distinct pleasure of appearing before most of these judges in the Court of Appeal, and they have contributed considerably to the jurisprudence in our country. The next case I'd like to discuss is a case called Kable, where I defended a soldier in the army of attempting to rape a 10-year-old girl. This was a very interesting case because the magistrate who was deciding the case or presiding over the case was a lady who took serious objection to the questions I was asking the complainants, the 10-year-old girl, in court. And she descended into the arena of conflict, as it were. And predictably, she convicted my client of attempted rape. I then filed grounds of appeal to the High Court and filed 9 grounds of appeal and won on ground 8 alone. So it is always important that a judicial officer should be detached from a trial and not descend into the arena. The next case was a very interesting case of King versus the state. This was a case in which a chap was convicted of murder and sentenced to death as a result of having sexual intercourse with his girlfriend, who died in the process of sexual intercourse. I then defended this chap in the High Court, but he came to me for his appeal when he was convicted of murder and sentenced to death. And when I got to the Court of Appeal, I was able to persuade the Court of Appeal that my client must have suffocated this lady without knowing what he was doing. In other words, when there was evidence that the woman was making sounds, I was able to persuade the Court of Appeal, and the judgment was given by Bezos, Justice of Appeal, that my client mistook those sounds for sexual gratification and not that he was suffocating the lady. The Court of Appeal, after hearing the arguments, decided on a matter of consolation and sympathy, took the accused, the appellant, off the death row and said that they were not going to pass the death sentence, but they would give their judgment at a later stage. But in the meantime, he could be taken off death row. The next case I did was a very interesting case. As I said, I've had a very interesting practice in Botswana, where the judge president of the Court of Appeal was my uncle-in-law. His sister was the mother of my former wife, and also my father-in-law was also a judge of the Court of Appeal, and it was a murder appeal in which my uncle-in-law, my father-in-law, and a justice of the Court of Appeal of South Africa, Kumlieben, sat. And these judges had come in with a preconceived idea as to the way in which the appeal should proceed. And they wanted to convict my client of manslaughter. I then sent to the judges, my lords, if your lordships will allow me to take you through the record and give you 30 minutes, I hope I'll be able to persuade your lordships that my client deserves to be acquitted. And of course, they very, very angrily said to me, okay, go ahead, as if I was talking rubbish. However, after 30 minutes, I was able to persuade the Court of Appeal that, in fact, my client deserved to be acquitted because he had been molested and fought by the deceased person who was a karate expert. And he had merely stabbed the deceased once in self-defense. And I recall in after the arguments, my uncle-in-law turning to my father-in-law and saying to him in the vernacular language, should we really be sitting on this appeal? And eventually they gave the judgment was written by Justice Vabil Komliben from South Africa. The next matter that I would like to discuss is a very interesting case, a murder case, where I defended an accused person who it had taken 12 years to bring his case to court. Normally, what most counsel have done in cases like that is they've applied for a stay of the trial on the basis that the accused has not been tried within a reasonable time. But what I did in this case was I did not apply for a stay of the trial. I proceeded with the trial, and I then got my client acquitted and discharged of murder. Then what I did was, for the first time in the history of the country, I sued the government for violation of my client's constitutional right to be tried within a reasonable time. I won the matter before Mr. Justice Kinyake and a landmark decision. Of course, the government was not very happy with the decision, and they appealed. And they instructed two counsel from South Africa, including a Silk. And I recall the judge president of our Court of Appeal, Justice Kirby, saying to me, Mr. Luke, are you not also going to appoint or instruct counsel to lead you in this appeal? And my response to the learned judge president was that I'm a barrister of England and Wales. I don't need to instruct a counsel. So the appeal was heard, the government lost the appeal, and the judgment is reported in our Botswana law report. In fact, it is not only reported in the Botswana law report, it is also reported in the Commonwealth law reports, and is a landmark decision on the right to ability to sue for breach of a person, an accused person's constitutional right to be tried within a reasonable time. The next case, of course, was the biggest murder case in Botswana's history. A South African lady called Marietta Bosch. Mrs. Bosch left the shores of Botswana and went across to South Africa to bring her husband's or her late husband's firearm from South Africa and smuggled the gun back into Botswana. She then apparently was charged with killing her best friend in order to marry her best friend's husband. The case was entirely circumstantial. Her evidence was that she did not do it. She raised a defense of alibi. And of course, the alibi defense failed. And once an alibi defense fails, there's nothing you can rely upon. And she was duly convicted of murder and sentenced to death. We then appealed to the Court of Appeal, and I instructed one of the top barristers in England, Sir Desmond de Silva QC, to come and argue the appeal in the Court of Appeal. It was the first time that an English barrister or QC has ever graced the courts of Botswana. The arguments presented by Sir Desmond de Silva were outstanding to behold. In fact, at the end of the hearing, the Court of Appeal hearing, which took 3 days, the then acting judge president of the Court of Appeal, the Honorable Justice Timothy Akunola Aguda, said that in my 21 years sitting as a judge of the Court of Appeal of Botswana, never before have I heard such brilliant submissions. I thought that we had won the appeal, but nevertheless, the Court of Appeal confirmed the conviction and sentence of death. This is a very interesting case because when I was doing the trial, my gut feeling was that I should not call Mrs. Bosch to the witness stand. And because I was very concerned that my learned friend for the prosecution would destroy her evidence in cross-examination. My former pupil master, Jonathan Goldberg QC, said to me that, Edward, you cannot play God for your client, that your client has to go into the witness box and testify. Well, Mrs. Bosch, during the trial, had a 50-50 case. When she went into the witness box, my learned friend for the prosecution tore her apart. In fact, the answer that she gave to some of the questions in cross-examination was so devastating that I slammed my hand on the table. And the learned judge said to me, Mr. Luke, are you surprised at the level of questions that are being asked of your clients by the prosecution? Of course, the answers that my client had given in that case was so bad that I knew that my client was going to be convicted. However, in the Court of Appeal, when we argued, Sir Desmond de Silva argued this matter in the Court of Appeal, he found that the learned judge in the court unquote had gone off the rails, as it were, when he came to consider the defense of the accused. For example, he said, the learned judge had said that it was for the accused to prove on a balance of probabilities that my client handed the gun over to someone else, a chap called Henry Kutsia. But of course, there's no onus of proof on an accused person in that. But however, the Court of Appeal found that because of the damning answers that my client had given in cross-examination, that notwithstanding the glaring errors made by the learned judge at the court quo, the evidence given by my clients in cross-examination was such that my client deserved to have her death sentence confirmed and conviction confirmed. So my gut feeling that I shouldn't put my client in a witness box would have worked if I had not put her there. Lastly, I will deal with another murder case, which I did, and that was before the learned Chief Justice, in which I represented 3 accused persons of murder. Fortunately for me, I was successful in putting all 3 of the accused persons. They were acquitted on a submission of no case to answer. Normally, I would have celebrated such a fantastic victory. I felt absolutely nothing. In fact, I just thought to myself that I have just let 3 guilty guys go free. When I thought that way, I said, it is now time for me to pack my bags as a defense lawyer. If I start feeling this way about a client of mine, then it is very, very disadvantageous to my client to have me as a defense lawyer. So I took 7 years to wind down my practice. Didn't do any more murder cases, didn't do any more trials, and changed my practice from a litigator into arbitration. And to become an arbitrator, I joined the Chartered Institute of Arbitrators, where I did a diploma in international commercial arbitration, membership of the Chartered Institute of Arbitrators, and I did a fellowship exams to make me a fellow of a Chartered Institute of Arbitrators. I learned from the very best. I trained under, well, first of all, let me say here, my interest in arbitration came when I was 16. I was living at Frobe College. My father was a university professor there. And we lived next door to a chap who was a professor of law, Professor Henry Joko Smat. And he told me, he used to come and pick me up to go to court with him. And I wasn't really impressed with him, his abilities as an advocate in court. And then he told me, he said, Edward, let me tell you a secret. I'm not like other lawyers in this country. What I do is I work as an arbitrator with the United Nations doing law of the sea arbitrations. I go to Geneva every year in June when the university breaks up, and I'm there till October doing arbitrations. And they pay me a significant amount of money. And then the seed of arbitration was born in me. And I've always wanted to become an arbitrator ever since. And so when I was called to the bar in England, I worked I did my pupillage in a leading set of chambers in London that does arbitration work, 4-pump court. And I worked with some of the finest arbitrators. And I was trained by Professor Jan Paulsen, who is regarded as one of the top 5 arbitrators in the world. I went to a special class of his, which he did at the University of Miami, called Special Practitioners Training for International Arbitrator for Practitioners. I learned a considerable amount from him. I also trained under Professor Richard Stern, Professor Martin Hunter, at King's College London in advanced training in international arbitration. From those international arbitrators, I learned a considerable amount. I learned probably in 2 years what it would have taken me on my own to learn in 30 years. I also attended a courses conducted by the ILA, African International Legal Awareness, which were held in London at some of the most prestigious law firms in London, Allen Overy, Sherman and Sterling, White and Case, to name a few. There, I went for 4 years in a row. I learned a considerable amount on international investment treaty arbitration. There was a considerable amount of learning and experience that I got from the very best arbitrators in the world. And so I became so fascinated with international arbitration that I wound down my practice entirely, and I don't do any more legal work. I do not like going to court. I have not been to court since 2015. And I thought that I would, in my career, I was inspired by the great English barrister Sir Edward Marshall Hall, who QC, who had defended so many people in court and was a courtroom barrister advocate for the rest of his life. I thought that is what I would do. But I cannot stand going to court anymore. And presently, I am working on a very big exit arbitration where my president is the Professor Gabriel Kaufman-Kohler, again, one of the top 5 arbitrators in the world. We have been sitting on this arbitration at the World Bank, exited the World Bank since 2020, the last 3 years. What I have learned from, and of course, my other co-arbitrator is Judge Thomas Johnson, who works on the Iran Claims Court in The Hague. These 2 persons who I work with on this arbitration have taught me a considerable amount. I am so delighted that I never took up the Chief Justice approach in 1999 to become a judge of the High Court of Botswana. There is no way I could have learned what I have learned by working with the very best in the world if I had been a judge of the High Court in Botswana. And the other advantage about arbitration is that you can choose what arbitration you're going to sit on. You're not, unlike being a judge, where you have no choice but to sit on any case that comes before you, unless, of course, you're conflicted, is such a great advantage. And in arbitration, you could look at arbitration and say, I don't want to do this arbitration, and you don't have to do it. And so it is a phenomenal job. It's a phenomenal career. It is really delightful. I enjoy being an arbitrator, and I am delighted that I've had the privilege of meeting some of the finest arbitrators in the world. I'm listed in the most prestigious Global Arbitration Review, who's who of the leading arbitrators in the world. To get into the Global Arbitration Review, who's who of the leading arbitrators in the world, within 2 years was a remarkable achievement. I thank God for it. I have been in that who's who of arbitrators in the world for the last 8 years. It is a joy to behold. And I think I'm finished. If anyone has any questions, I am willing to take them. Thank you.
Good afternoon, Mr. Luke.
Good afternoon.
It's Laura here. I don't have a question because I just joined now. I wasn't able to join earlier, but I just wanted to thank you for coming in to give a session.
You're most welcome. Hello? Hello?
Good afternoon, Mr. Edwards.
Good afternoon to you.
Yes, it's July again. I think Laura was just appreciating the time that you made to come and give us your experience that you have. And I have not seen anyone raising any questions.
Yeah, right. Okay. That's nice to hear.
July.
Hello?
Mr. Edwards, am I audible?
Yes, you are.
Okay. I was listening. I was so interested too because I found that you've got a rich history, a rich experience and practice of this field of specialization. Really, I really appreciate. I've actually grabbed something from all what you've been debating. Thank you so much, sir.
You're most welcome. You're most welcome.
I don't see. Thank you, sir. Thank you so much.
You're welcome. Anyone else? Hello?
I don't see anyone raising their hands. So I think that would conclude the presentation for today.
Right. Let me just say one thing. I would like to say to my Nigerian viewers or Nigerian hearers that I had the great privilege of appearing before one of their finest judges, Justice Akinola Aguda. And I appeared before him in a court of appeal for about 15 years. And it was a joy to behold, to appear before such a very, very distinguished and brilliant jurist. And finally, if I conclude by saying that one of the advantages we've had in Botswana is we've had a fantastic court of appeal. With some of the finest judges you can find, including law lords from England and Scotland.
Mr. Luke, are you still on?
Yes, I am.
Yes, I think we no longer have any questions from the floor, so we really appreciate the time that you made to come and give us a presentation and the experiences that you've faced. So thanks a lot. We'll make this presentation available on our YouTube channel by tomorrow. So anyone
Oh,
who wants to
splendid.
access it can access it from there.
Oh, splendid. Will you send it to me, please?
I'll definitely make sure that you get the link by tomorrow morning.
Oh, thank you, sir. Thank you so very much. Much appreciated.
Thank you.
Thank you, sir. God bless you.
Bye-bye.
Bye.
Thank you. Bye.
Bye.